Hello, I'm Carlton Van Putten, founder and CEO of PayRent. Welcome to the Keys to Success podcast, where we unlock the secrets to smarter investments, smoother tenant management, and bigger profits, one episode at a time. Ready to master your property game? Let's dive in.
Welcome back to Keys to Success, the podcast that brings you the know-how to thrive as a landlord. And today we're tackling a topic that can be a real headache for landlords: evictions.
Ooh, yeah.
We're going to dive deep into the complete guide to the eviction process to help you understand how to navigate this tricky terrain legally and effectively. Just in case you ever need to go down that road.
What's interesting about evictions is that they're often seen as this adversarial process.
Yeah.
But understanding the legal ins and outs can actually empower you as a landlord. It's all about protecting your rights and making sure you're playing by the rules.
So it's not as simple as just changing the locks when a tenant misses rent. I've heard some landlords talk about that.
Definitely not. You can't just skip the legal process. It's there to protect both sides. And taking matters into your own hands could land you in hot water legally. Tenants have rights too, and those rights are enshrined in the law.
Okay, so let's talk about what actually triggers an eviction. What are the most common reasons landlords find themselves in this situation?
The two big ones are non-payment of rent and lease violations.
Okay.
Non-payment is pretty straightforward, but lease violations can cover a wider range of issues. Think unauthorized pets, damage beyond normal wear and tear, or even illegal activities happening on the property. Basically anything that goes against the lease agreement.
So if a tenant isn't paying rent or is violating the lease, what's the very first step a landlord needs to take?
It all starts with serving the tenant with the correct notice. This is a legal requirement, and it's the foundation of the entire eviction process. It gives the tenant a chance to fix the problem before things escalate. And messing this up can really derail the whole eviction.
I've heard there are different types of notices. Can you break those down for us?
You're right. There isn't just one generic get out notice. The type of notice depends on the specific violation. In Florida, for example, you have a 3-day notice to pay rent or quit for unpaid rent. This gives the tenant 3 days to pay up or move out. For lease violations, there's a 7-day notice to cure or quit, which gives the tenant a week to fix the problem, like removing an unauthorized pet or repairing damage.
Gotcha.
Then there's the unconditional quit notice for more serious violations that can't be fixed, like illegal activities on the property.
That makes sense. So let's say a tenant in Florida gets a notice.
Right.
But doesn't pay the rent or fix the violation. What happens then?
If the tenant doesn't respond to the notice, the next step is filing an eviction lawsuit.
Okay.
This officially kicks off the court process, usually starting in the county court where the property is located.
So you can't just march into court and say, hey, my tenant isn't paying. What do you need to do to actually file that lawsuit?
You need to gather all the necessary documentation to support your claim. This includes a copy of the signed lease agreement, copies of any notices you served, and something called proof of service.
Proof of service. What's that all about? It sounds like legal jargon.
Proof of service simply means you have to be able to prove the tenant actually received the notice, not just that you sent it. It's like having a receipt for the notice.
Okay.
This usually involves having the notice delivered in a way that provides a record, like certified mail, or having a process server hand deliver it and sign an affidavit. Without this proof, the case could be delayed or even thrown out.
So it's not enough to just stick a notice on the door.
Right. You need that verifiable proof. Think of it this way. If you were taking someone to court for any reason, you'd need to show that they were properly notified. The same principle applies here.
Okay. I'm starting to see just how much attention to detail is needed here. It's not as simple as some people might think.
That's exactly right. Evictions are a legal process, and the courts expect landlords to handle them with care and precision. And that includes keeping meticulous records of absolutely everything. Every communication with the tenant, every payment or mispayment, every instance of a lease violation. Document it all. This documentation can be your lifeline if the case ends up in court.
So documentation is like a landlord's secret weapon.
You could say that. Solid documentation can make all the difference in proving your case and getting a favorable outcome. It shows the judge that you've acted professionally and by the book every step of the way.
And speaking of the legal side of things, I know filing a lawsuit can be expensive. What are we talking about in terms of costs here in Florida?
Well, the filing fee for an eviction lawsuit in Florida is currently around $185, and you might need to pay for a process server to deliver the summons,
Okay.
which is the document that officially informs the tenant about the lawsuit and the court date.
So those costs can add up quickly. I bet a lot of landlords don't realize that going in.
You're absolutely right. It's definitely something to factor into the equation when deciding whether to pursue an eviction. Sometimes it might be worth considering other options first, like mediation, to see if you can resolve the issue without going to court.
That's a great point. Maybe we can dive into those alternative options a bit later. So let's say the lawsuit is filed, the fees are paid, and the tenant has been served with the summons. What happens next in this legal journey?
Once the tenant is served, they have a limited time to respond to the complaint. In Florida, that's 5 business days.
5 business days. And what if they just ignore it and don't respond?
If the tenant doesn't respond within that time frame, you can request a default judgment from the court. This means you automatically win the case because the tenant didn't show up to defend themselves.
So that can speed up the process quite a bit.
It can, but even with a default judgment, you still need to follow the proper legal procedures to actually remove the tenant from the property. You can't just go in there and start changing locks.
Okay, I'm all ears. What are those procedures? What happens after that judgment is issued?
If you win the case, the court will issue you something called a writ of possession.
Okay.
This document gives you the legal right to take back your property.
So that's the golden ticket. But if the court says I can take back my property, why can't I just do it? Why can't I just go change the locks now?
Because the law requires that evictions be carried out by the sheriff or a designated law enforcement officer. They're the only ones authorized to physically remove a tenant.
So even with a court order in my hand, I can't just show up and start moving the tenant's stuff out myself.
Exactly. In fact, doing that could get you in serious legal trouble. You have to go through the proper channels and let the sheriff handle the removal.
Okay, so what happens when the sheriff arrives? Do they just escort the tenant out peacefully? Or can it get messy?
The sheriff will usually try to handle things peacefully. They'll arrive with the writ of possession and ask the tenant to leave. But if the tenant refuses or resists, the sheriff has the authority to remove them forcibly. And you, as the landlord, need to be prepared for that possibility. It's wise to have a plan for securing the property and potentially storing the tenant's belongings.
Wow, I never thought about that. So even after you've won in court, things can still get complicated.
Yes. And that's why understanding tenant defenses is crucial for landlords. If you know what arguments a tenant might raise, you can be better prepared to counter them.
No.
And avoid potential pitfalls that could drag out the process.
Speaking of tenant defenses, what are some of the most common ones we see?
One of the most frequent defenses revolves around the issue of notice. A tenant might argue that they weren't given proper notice, that the notice was defective in some way, like an incorrect date or address, or that it wasn't served correctly.
So if I messed up the notice even by a little bit,
Yeah.
the tenant could use that to fight the eviction.
Yes, even a small error could give them grounds to challenge the eviction. That's why it's so crucial to get those notices right. Don't just download a generic form from the internet. Have an attorney look it over. Or use a service that specializes in creating legally sound notices.
Okay, that's a good tip. What about cases where a tenant claims they paid rent, but there was a mix-up? We talked about payment discrepancies earlier.
Right. A tenant might say they sent the rent, but it got lost in the mail, or deposited into the wrong account. Or they might argue that they withheld rent because of a legitimate dispute over repairs.
So it becomes a he said, she said situation. And it's my word against theirs.
It could. And that's why documentation is so important. If you have solid records showing that the rent was not received, like bank statements or copies of returned checks, you're in a much stronger position to refute that defense.
Sounds like keeping organized records is half the battle in this whole eviction process.
You're absolutely right. And it's not just about winning in court. Good record keeping can actually help prevent disputes from escalating to the point of needing an eviction in the first place. If you can demonstrate a clear history of addressing issues promptly and communicating effectively with your tenants, you're much less likely to end up in these difficult situations.
So being organized and proactive can save you a lot of hassle in the long run. Makes sense. Now, what about repairs? How often do tenants try to use those as a defense against eviction?
It's not uncommon at all. Tenants might argue that you, as the landlord, failed to address essential repairs, making the property uninhabitable. or violating local housing codes. They might claim they had to withhold rent or pay for repairs themselves because you were neglecting your responsibilities.
So how can landlords protect themselves against that kind of defense?
Again, it comes down to documentation. Keep a record of all repair requests, communication with tenants about repairs, and any actions you've taken to address the issues. If you have proof that you responded promptly to repair requests and acted in good faith to maintain the property, it will be much harder for a tenant to use this defense successfully.
I'm starting to see a pattern here. Good communication and solid documentation are like a landlord's superpower.
That's a great way to put it. Now, we've talked about defenses based on genuine issues, but what about those cases where a tenant knows they're in the wrong and they're just trying to delay the inevitable?
The classic stalling tactics. I've heard horror stories about tenants dragging out the process for months.
It does happen. Some tenants will use every trick in the book to buy themselves more time, whether it's filing frivolous motions, requesting multiple continuances, or even failing to appear in court.
So how can landlords deal with those situations?
First of all, don't panic. The courts are generally aware of these delaying tactics, and they have ways to prevent them from unduly prolonging the process. An experienced eviction attorney can help you navigate these challenges and keep the case moving forward.
Okay, so having a good lawyer on your side can make a big difference.
Absolutely. And remember, even when it feels like the tenant is trying to play games, it's important to stay calm, professional, and stick to the legal procedures. Getting emotional or taking matters into your own hands will only hurt your case.
Great advice. So we've covered a lot of ground here, but I want to make sure our listeners walk away with some actionable takeaways. What are the top 3 things landlords should keep in mind when it comes to navigating evictions?
First and foremost, know the law. Landlord-tenant laws are specific to your state. So familiarize yourself with the requirements and procedures where you own property.
So don't assume that what you hear from other landlords or read online applies to your situation.
Exactly. Laws can vary significantly from state to state. Second, document everything. Keep detailed records of lease agreements, payments, communication with tenants, repairs, and anything else related to the tenancy. This documentation will be your best defense if you ever have to go to court.
Okay, know the law and document everything. What's the third key takeaway?
Don't be afraid to seek legal advice early in the process. An experienced eviction attorney can guide you through the complexities of the law, help you avoid costly mistakes, and protect your interests.
That's great advice. Sometimes it's better to be safe than sorry and get professional help.
Absolutely. It's an investment that can save you time, money, and a lot of stress in the long run.
This has been incredibly informative. I feel like I have a much better grasp of how to handle evictions now.
I'm glad to hear that. And to really drive these points home, I think it would be helpful to look at some real-world case studies.
Oh, I love that idea. Case studies always help me see how the theory plays out in practice.
Exactly. So in our final part, we'll dive into some specific scenarios and analyze how different landlords handled various eviction challenges. I think it will be a great way to wrap up our deep dive and leave our listeners with some actionable insights they can apply to their own situations.
Welcome back to Keys to Success. We're wrapping up our deep dive into the eviction process, and I'm really excited about the case studies you mentioned. I think they'll help solidify everything we've talked about so far.
I agree. Sometimes seeing how these situations play out in real life can make all the difference. So for our first case study,
Okay.
let's imagine a landlord who's dealing with a tenant who's constantly late with rent. Month after month, the rent trickles in, always with a new excuse.
I know landlords like that. They don't want to be the bad guy, so they let things slide. What could go wrong with that approach?
We'll imagine that the tenant eventually misses a payment altogether. The landlord, fed up, decides to start the eviction process. They serve the tenant with a notice, but the tenant fights back, arguing that they've always been allowed to pay late in the past.
Oh, I see where this is going. The landlord's leniency is coming back to bite them.
Exactly. By consistently accepting late payments, the landlord may have inadvertently modified the original terms of the lease. And without clear documentation to prove otherwise, their case could be weakened in court.
That's a tough lesson. It makes you realize that even being a nice landlord can backfire if you're not careful about the legal side of things.
It's a delicate balance. You want to be understanding and work with your tenants whenever possible, but you also need to protect yourself legally. And that means upholding the terms of the lease and documenting any deviations from the agreement.
Okay, so what's our next case study?
Let's shift gears to a situation where a landlord is dealing with a tenant who's causing damage to the property.
Okay.
We're talking noise complaints, parties, maybe even suspected drug activity. A real headache tenant.
That sounds like a nightmare. I can't imagine dealing with that.
It's definitely not easy. So the landlord follows the proper procedures, serves the tenant with a notice, gives them a chance to fix the problems, but the tenant just ignores it and keeps up the disruptive behavior.
So the landlord takes them to courts. Right. What happens then?
The landlord files for eviction. But here's where things get tricky. The tenant, realizing they're probably going to lose, decides to retaliate.
Oh, no.
They intentionally damage the property even further, creating a bigger mess for the landlord.
Wow, that's awful. So even when a landlord is doing everything right, they can still get hit with these unexpected challenges.
Unfortunately, yes. Evictions can be emotionally charged situations, and some tenants might react poorly. That's why it's so crucial to document the condition of the property before, during, and after the eviction process.
Okay.
Take photos, videos, anything that can help prove the extent of the damage and protect you from false claims.
That's a good reminder. It's like creating a visual paper trail to support your case.
Exactly. Now let's look at a case where a landlord successfully navigates the eviction process. This time we have a tenant who has simply stopped paying rent due to financial hardship.
That's a tough situation. I know a lot of landlords would struggle with how to handle that.
This particular landlord, recognizing the tenant's difficulties, tries to work with them. They offer a payment plan, point them towards resources for rental assistance. They really try to find a solution.
So they're not just throwing the book at the tenant immediately.
Right. But the tenant is unresponsive and unwilling to cooperate, so the landlord has no choice but to proceed with the eviction.
And how does this landlord make sure they're protected legally?
This landlord understands the power of documentation. They've kept records of every communication with the tenant, every offer of assistance, and every missed payment. They've also followed all the legal procedures to a T.
So it's a combination of compassion and careful documentation.
Exactly. And when the case goes to court, the landlord is well prepared. They have a clear timeline of events supported by evidence, demonstrating that they tried to work with the tenant but ultimately had no other option.
It sounds like preparation and thorough documentation were key to the landlord's success in this case.
Absolutely. It highlights the importance of being proactive, organized, and knowledgeable about your rights and responsibilities as a landlord.
These case studies have been so helpful. I feel like I've learned more from these real-world examples than I ever could from just reading the law.
That's what makes these deep dives so valuable. It's not just about the legal theory. It's about understanding how it all plays out in the real world.
Well, this has been a fantastic deep dive into the eviction process. We've covered everything from the legal basics to tenant defenses, successful landlord strategies, and even those tricky real-world scenarios.
I hope our listeners feel empowered to approach these situations strategically and confidently, knowing that they have the tools and knowledge to protect their interests.
I think they do. Thanks for joining us on Keys to Success. And remember, knowledge is power when it comes to being a successful landlord.
We hope you enjoyed this episode of Keys to Success. I invite you to check out past episodes and follow us on your favorite podcast platform to get notified when new ones are released. And when you're ready to simplify managing your properties, be sure to visit us at www.payrent.com.